Hello and welcome to Friday Live. I am your host, Strata lawyer Amanda Farmer. We're going out live to the Your Strata Property Facebook page. We are heading out to YouTube. We are heading out to LinkedIn. How are you all this Friday afternoon? What's the weather like where you are? It has been a very wet, very rainy day here where I am. I think there's a little bit of weather around different parts of the country. I have been tucked up here in my home office, smashing through the long list of Strata commitments. I've been preparing some CPD content that's compulsory, continuing, that's how it's been going, continuing professional development content for sales agents and property managers. So that's been exciting, teaching them about Strata. That's where a lot of my time has been spent today. I've been drafting some bylaws. I was up early this morning, logging in to complete an online Strata search for one of my clients with all of the usual frustrations when inspecting records held by Strata managers, things that are missing, a system that is quite clunky. We'll be sorting that one out in due course. It is all happening in Strataland. What have you been up to today? You're already jumping in, letting me know that you're here. Kristen's here saying hi and looking forward to this afternoon's chat as usual. Great to see you, Kristen. Petra is here. Hey, Petra. Hello, Sean. Little grey on the lower North Shore. Yeah, I think it's been a bit wet in Sydney, at least from my Googling and having a look at the weather around the country. Hey, Vivian, how you doing? Lots of you coming in live. If you are joining us for the first time, let me know. I always like to give you a special welcome. We've got lots of new followers here on the Facebook page. We've got a few new members inside our online community as well. So if you're coming in, this is your first live chat, first Friday live, let me know. Deborah's telling me I'm new. Hello, Deborah. Welcome. You are in the right place. Hey, Maureen. Hey, Kareem. Good to see you again too. Hey, Jan. I am good. How are you? Interesting earrings, says Bill and Ben. Look, I like to shake things up every now and then. I figure if I'm haven't put the effort in to wear some color, I'm going to put some color in my ears for you guys. Thank you. These are a local artist here in Mudgee. So as many of you know, I'm lucky enough to call Mudgee home and pick these ones up from one of our local artists. Kyria, I hope I'm saying that correctly. Can we have a list of things to gather from a property search, please? Straight in there, Kyria. Straight in with the questions. Noted. We're just warming up. Here. You got questions. I have some answers. Not sure I'm going to have that answer for you today, but I can definitely let you know where you can go to get that one answered. Hey, Wendy. Sean is here on his new Facebook profile. Yeah, heard about that, Sean. Glad that you have made it and sorry that you were the victim of that awful behavior. We have the two Seans. Let's cross our fingers for the Sean trifecta this afternoon. Great to have you all here with me. There is a little bit to talk about. Some of you will have received my email this afternoon. If you're not getting my emails, just pop into the chat there. Rochelle and Mina are here helping out as usual, the dream team. And if you don't get my emails on a Friday to let you know what we're chatting about and you wonder, how does everybody know what Amanda's going to be talking about? Just drop a note in the comments or send us a private message and we will get that sorted out for you. Kiri, first time. Lovely, Kiri. Thank you very much for joining us. Jan's dad had a farm near Golgong Mudgee called Tarawong. Good to know, Jan. There's always someone who knows someone around these parts. And Sean had coffee with Sean 3 a week. Which one is Sean 3? I don't know. Sean, is that Sean B? Sean B, Sean 3. Lovely to see you, Chris Scott. Deborah's telling me I'm probably going to NCAT for an exclusive use bylaw. Okay. You've all been busy in Strata as always. Did you listen to this week's podcast episode. We're up to episode number 410. Some of our episodes, I have a guest and we're talking about maybe a new innovation, a new product that might be around. Sometimes I'm chatting to Rena about strata management practices. And sometimes I can go a little bit deep on some technical aspects of our strata law and strata living, the practice of strata living. And that was this week's episode. I pulled out 3 what I called listener questions. And these were actually questions, if you tune in, you'll hear me say they're questions that were submitted for an Ask Amanda Now session, which we do here on the page every couple of weeks or so. Questions that I hadn't got to in one of those sessions. So brought them over to the podcast to answer. We had a look at termites. Who's responsible for dealing with termites in a strata building? Hope you never have to face that situation in your buildings, but if you do, who's responsible for getting rid of them, for treating them, for solving that problem? Great question from Denton. And I know from the comments on the podcast page that Denton was able to tune in and was grateful for that question being answered. Thank you, Denton. I answered Veronica's question about the strata manager's authority to appear before the tribunal on behalf of committee members and whether or not Veronica needs to contribute to the costs of the strata manager doing that. Really great question. And Suzanne asked a question about security cameras and a security camera attached to her neighbour's lot, whether that was legal, whether a camera that seems to be looking into Suzanne's backyard, whether that was allowed to stay in place without approval from the owners corporation. So chose those questions because they are great ones, that not the first time that I've heard those questions, and I'm sure the answers to those have been helpful to many. So thank you to Veronica, Suzanne, Denton for asking those questions. And if you haven't yet been over to check out podcast episode number 410, we got the link here in the comments for you. Sean is telling me that Sean 3 is Sean B. That's a good way to remember it. Thank you, Sean, because it rhymes. And Sean B is here with a wave. Thank you, Sean Trifecta. Welcome. Kristen says she loved the Mashup podcast this week. Thank you. Yeah, cool. Thank you, Kristen. I quite enjoyed recording that one. And as you know, because I'm here most weeks, answering questions live for you, and also in our member forum every day, answering questions in writing for you. It's one of my favorite things to do. So no reason not to bring that to the podcast. Chu is here saying, hi, Amanda. Lovely to see you. As I said, if you're coming in and it's your first time joining us, don't be afraid. We are a lovely bunch. We're not scary. We're very welcoming. We would love to know that you're here tuning in. Okay. So I do have a case for you this week. I've been doing this more often, bringing you these usually unreported cases that are coming out of our tribunal. They are cases that I know about either because I was involved in them, my client was involved in them, or they've been sent to me by one of you, which I always welcome. Please do send me your tribunal decisions, particularly where they have reasons attached explaining how the tribunal came to its decision. They could be reported cases that are really important and I feel need to be brought to your attention. But I've been doing this a little bit more often, possibly because I've had a little bit of backlog of litigation in my legal practice where we're getting decisions coming through now, which is great. And also because you're telling me that you really love learning from these cases. And I think, I keep saying it, but now more than ever, more of you are feeling the need to go to the tribunal, to seek the intervention of the tribunal because you have non-responsive strata committees, you have buildings with big problems, you are recognizing that that path is there and available to you to solve those problems, yet it is expensive to be engaging a specialist strata lawyer to help you along the way. And that is why I think, I hope and I hear that you get so much benefit from looking at these cases and seeing how owners who have come before you have been successful and using them as a bit of a template for your own proceedings. So definitely got one of those for you today. We are absolutely going to get to that. Before then, however, you may have heard, I'd be interested to know if you've heard about this through other channels, because I'm wondering who might be talking about it. I haven't seen it on other channels, but I'm not connected on all the channels. Interested if you have heard about the undertaking that has now been given by Netstrata to the Commissioner for Fair Trading in New South Wales. This is an undertaking that is publicly available. It's no secret. It is on Fair Trading's public register of undertakings on their website. I do have a link for you if you want to have a read through it. I've got it sitting here next to me in hard copy as well. It's about, 10 or so pages. Short, a little bit dense though. So I've got a bit of a summary here for you today. We have posted here on the page, I posted here on the page last night about the undertaking with a few summary points, and time to talk about it. I'm interested to know what you think. Kristen's telling me I haven't seen the undertaking anywhere else. Thank you for bringing it to our attention. Sean is saying, yes, please, link for the Netstrata undertaking. Sean, you're usually the one who tells me whether SCA has talked about this to its members, whether there's been a fair trading email that I might have missed, whether there's anything on LinkedIn. I would have thought, being such a contentious matter that has had quite a lot of public attention and media attention, that when this undertaking was given, it would have been brought to the attention of the strata sector. So when I realized that hadn't happened and the undertaking was out there, I was happy to post that link for you, and I'm happy to have a chat about it now. Some of you have already had a look at it and shared your comments with me, and I'm going to come to those. Shana is saying, happy Friday from Coffs Harbour. Lovely to see you, Shana. Natalie, nice to see you. Welcome. SCA are doing member audits, but I haven't seen anything else. Okay, not sure what a member audit is. I'd be interested to know more about that, Nat. So this is the result of Netstrata's promise to allow fair trading to investigate its business practices coming out of the ABC News expose about those practices. Unless you have just come into Strata in the last month or so, or been offline, I envy you if you have been. I'm sure you're well aware of the ABC story that broke in March this year. I'm not going to cover that old ground, but when that story came out, Netstrata was quick to say, we're going to open up our records, open up our practice to fair trading for their inspectors to come and have a look and see everything that we have been doing and take it from there. The way that that has been able to happen, or the structure around that, the framing around that, has been done in the form of Netstrata giving an undertaking, a promise, a legal promise to the Commissioner for Fair Trading to do certain things, to commit to certain things, to open up access to certain records. And that has all been recorded in this document, which is an undertaking to the Commissioner for Fair Trading by Network Strata Services. It's an undertaking that's given under the Property Stock Agents Act of 2002. So I pulled out a few headline items from the undertaking. Fair Trading has engaged an advisory firm, McGrath-Nichol Advisory, to carry out the investigation. I'm assuming that's on the basis that Fair Trading doesn't really have the resources, perhaps doesn't have the unique skills that it needs to do this kind of investigation. So makes sense, good idea to bring in the experts. Netstrata is going to pay McGrath-Nichol's fees, and it's quite clear in the undertaking that there is a commitment to pay up to $300,000 for McGrath-Nichol's independent review of Netstrata's business structure and their practices, but McGrath-Nicol is certainly taking their instructions from New South Wales Fair Trading. By this undertaking, Netstrata agrees to fully cooperate in the independent review. There's a few it's interesting when you look at these documents through the lens of a lawyer, and you can kind of see how the drafting has been shaped by each party to the agreement and their lawyers. And there's certainly paragraphs in this undertaking where you can see that the words reasonable and to a reasonable level and to a reasonable extent have been inserted. So in my summary of the undertaking, which you'll see here on the page, I've said Netstrata will fully cooperate in the independent review to a reasonable level, and those words are scattered. That word is scattered throughout the undertaking. And Netstrata is going to review McGrath-Nicol's draft report and provide its comments. It has the opportunity to do that, and it has the opportunity to let McGrath-Nicol know if there's anything in there that it wants to be redacted, to be taken out before the report is published. Netstrata doesn't have the final say on that, but McGrath-Nicol can take those wishes into account. There's no admissions and no concessions by Netstrata about the allegations that were published by the ABC in March 2024. And whatever McGrath-Nicol discovers, whatever conclusions they draw, whatever recommendations they may make in their report, which will ultimately go to Fair Trading, will not be binding on Netstrata. So there will be findings, there will be recommendations coming out of this investigation. Fair Trading may make that report public, so we may get to see that report. But whatever those recommendations are, they are not going to be binding on Netstrata. So, your thoughts. Let me know what you think about that. Sorry, losing my voice. Kristen saying, I think you had the scoop and took it. Thank you. No worries. Kristen, I was sitting there for a couple of weeks. And I had known about it for a couple of weeks. I was waiting for somebody to say something. It was signed on the 1st of May, so it's been around for a little while. Chris is saying, yes, have heard about the undertaking and pleased to see some accountability. Sean saying, very interesting, very lawyer speak heavy. No offense. You can never offend me, Sean. Yes, it is a little bit hard to read. Sean saying SCA New South Wales is required to do a random audit of 10% of its members every year, at least under the terms of the legislated professional standard scheme. Okay, interesting. I wonder what that audit involves and whether there's been a different angle taken on those audits lately. Sean says it seems to be a way for Netstrata to say we're cooperating within the scope of our rights and responsibilities. And Philip says a very weak outcome. Thank you for your comments. They're not the only comments that I've received, and certainly on the page here. I know, Kristen, you posted yesterday, I think, having had a look at the post, and it sounds like having had a look at the undertaking, and you've said, so there is to be an independent review of Netstrata, but Netstrata is funding the review, wants to advise on redactions, and will not consider any recommendations of the review as binding. And Fair Trading signed this and accepted it, is Kristen's point. Certainly an interesting turn of events. Philip has said earlier, Kristen, don't forget the part where Fair Trading may not release the report publicly. And in Philip's view, $300,000 won't get much of an in-depth report at today's consultant rates. And we've certainly heard from Zlata. Zlata, as always, willing to give her opinion. I don't know if you're tuning in today, Zlata. But Zlata said the strata industry has and continues to be run by cowboys used to bullying owners and defrauding lot owners, is Zlata's view. Here's the thing. I'm not sure that New South Wales Fair Trading can do at this stage much more than this, and has only been able to do this because Netstrata has agreed to give the undertaking to open up its books, open up its offices, and allow this investigation to take place. There may be some findings that come out of this. There may be some material obtained, some evidence obtained, some documents, some concessions, some admissions, I'm not sure, that come out of this that Fair Trading will then be able to take and go and do something else with. I don't know. But I hear what you're saying. Seems like a weak response. Is this all they're doing? Is this a joke? At this stage, I think this is probably all that is available to Fair Trading to deal with those allegations and those admissions, indeed, that came out of that media reporting. The question is going to be, as I think it has been since this story broke, has Netstrata done anything illegal? Maybe that will come out of this investigation. Maybe what will come out of this investigation is that they haven't done anything illegal. I completely anticipate that there has been involvement from legal advisors, from legal representatives, all the way through the steps that Netstrata has been taking. And there's quite a mention of legal professional privilege, legal advice. That privilege is not waived when these investigators go in to have a look at Netstrata's materials. So I would be assuming that Netstrata, in issuing this invitation, would be feeling fairly confident in its position. And I think one of you has mentioned that, Sean. Yes, it's Netstrata just saying we're cooperating within the scope of our rights and responsibilities. I don't think you would do that if you were concerned that you might end up on the wrong side of the law. So it then leaves the question, if the behaviour that has come out through the ABC reporting, if that behaviour is illegal, is it still unacceptable? These practices might be legal, but are they ethical? Are they moral? Are they professional practices? And that's the conversation that I think needs to continue to happen around this, so that it is not back to business as usual for certain strata management companies and strata service providers. Hard to say, hard to predict what might come out of this, but you can trust that I will be letting you know how it's progressing. Heading back over to those comments, Sean's saying the professional services scheme audit primarily is that members are fulfilling their requirements under the scheme, not any fair trading requirements. So disclosure of limited liability, complaints processes. Yeah. So lawyers are part of this professional standards scheme as well. So it's a process that we're certainly familiar with. Kiri saying PR exercise. Yeah, absolutely. I would think so, Kiri. Chu is saying, I have tried complaining to SCA against our strata manager who's a member, but they ignored the complaints. They shouldn't be ignoring those complaints. There is a complaints procedure there for SCA, and as a member of a professional standards scheme, that needs to be fairly robust, Choose. So I would be pressing on that one. The complaints certainly shouldn't be ignored. I can see Sean stepping in there and offering a direct message, which is great. Thank you, Sean. Okay. Too many loopholes is the question from Sean. Wenna, great to see you. Welcome. Wenna saying the way this process is being managed by Fair Trading and the results/sanctions will set a benchmark for other strata management firms who dare walk the same path or entertain the same greedy thinking. Thank you for encapsulating that, Wenna. My thoughts exactly. Let's hope that there will be some results and perhaps some sanctions, if that is appropriate, coming out of this investigation. As I've said previously here on one of these chats, when I have this conversation about these practices, about what's been exposed by the ABC, about what's been admitted, and I keep coming back to these are a lot of these practices are not alleged practices anymore. They have been admitted on to the media. When I think about it and I think about the fallout from that and what's going to happen next, there's a little knot here in the stomach that is a little bit concerned that nothing much is going to happen. Not for lack of lawyers, particular lawyers talking about it. At the end of the day, this is the strata management sector. Accepting that we've had some conversations about where other strata service providers may be engaged in questionable conduct, but the strata management sector really does need to take some ownership and take some leadership around this problem and push it towards a solution and better practices for the future. I'm not seeing that yet. Could well be that we're all waiting for the outcome of this investigation, and let's see what happens then. Jan saying she tried to join SCA. They refused my application. I'm assuming Jan joining as a member of the owner chapter. Do they still have an owner chapter? I'm not an SCA member. I'm not an SCA member because I like to be able to speak freely. And as I understand it, some SCA members feel that they can't speak freely without some kind of repercussions. So I'm not an SCA member. I don't know why they would refuse your application, Jan, or if that structure is still around of having owner chapters or owner associations or whatever it is. Or Jan, do you have a strata manager license that I didn't know about? Interesting what the membership criteria might be. Chu is saying, what with the new record keeping, which will take effect in June, will happen to strata agencies and committee members? I wonder if you're talking there, Chu, about the electronic record, the need to keep electronic records, because you've reminded me, you're right, when our December changes to the New South Wales legislation came in, that was a delayed commencement for that provision that strata management agencies had 6 months until they had to comply with that requirement to keep electronic records. I don't think that's going to change much in the context of what we're talking about. Philip saying SCA and Fair Trading have been sitting on complaints for 5 months. They say it's still being investigated. Are those complaints specific to a strata management company, Philip, or just complaints generally? I imagine there's a lot of complaints coming through. I would love to see what Linton Besser at the ABC is receiving, having opened up that forum and encouraged owners to share their strata stories. I imagine that he was inundated with lots of experiences, and I'm wondering where that's going to go. Hopefully it can go to Fair Trading so that they can be armed with that information as well. Phoebe's saying, what a joke, what a ruse. This is not an independent investigation. He who pays the piper calls the tune. Well, Phoebe, this is the nature of an enforceable undertaking. You'll see attached to this, if you guys can get that far through the legalese, the schedule attached is the agreed scope of the review. So this list of items that McGrath-Nicol is going to investigate and report on are agreed items. This is the only way that something like this could be done. So it's, definitely done on terms that both parties have been willing to accept. Sean saying, I personally doubt it will change much as most strata managers are already e-recording. Yes, so that's about the electronic records. And I don't think for some time now, I don't think I've come across a strata management company that is not keeping electronic records. Certainly come across self-managed buildings. Natalie's telling me that she thinks that little knot that I have in my tummy about this is correct, and sad indeed. Sean's saying I don't think SCA have an owner chapter any longer. Natalie agrees with that. Okay, lots of conversation going on there. Diane is saying, how can we get a handle on what are reasonable charges by strata agencies? Any tips on how to hold to agreed standards and services? Constantly charged for having to follow up hours for what hasn't been done properly at all or in a timely manner. Yeah, you're not alone in having that concern, Diane. My primary piece of guidance when I hear that complaint is don't suffer in silence. If you have a difficulty with your strata manager's communication, with their level of service, with getting things done, please, if you haven't already, have a chat to them about that. And that's not just sending an email, that's picking up the phone and having a chat, setting a time for a meeting, go into the office, have a meeting in person. And I know we're all time poor and it's really hard to carve out the time for this, but setting that up if you can, having that chat face to face to explain what it is that you're unhappy about. Perhaps going up the chain if it's a larger company and you can talk to somebody who is a team leader or a higher level manager. It could be that a different manager could be allocated to your building who might be a better fit. It could be that the service improves after you have that serious chat. If it doesn't, then when it comes around time for renewal, you can, in good conscience and with some confidence, be saying to that strata manager, you're just not cutting it. And we've had this conversation and we feel we have no choice but to move on and try a different service provider who might be better able to meet our needs. But at least you can say that you've tried. And if you're very early on in that contract, maybe you're in the first year of a 3-year contract and you really don't want to stick it out, then you do have the option of proposing an early termination by mutual consent. So you can do that under the terms of your agreement and under the New South Wales legislation. But you're not going to get that mutual consent, I think, unless you've first had the conversation and understood what it is that's going wrong. I know a lot of strata managers who tell me, Amanda, there's quite a few buildings that I would rather not have on my books at the moment because we're too busy, they're too demanding, we can't meet their needs. And if only they would agree, we'd be happy to finish up our contract early. So sometimes you can have a meeting of the minds in that respect, but you've got to be open and have that open communication first. Kiri's saying, what length of time should a strata management contract be? So in New South Wales, we have maximum 3-year terms. Kiri, I'm not sure if you're in New South Wales, but maximum 3-year terms here. I see anywhere between 1 year and 3 years. I know good strata managers like Rena Van Alst, who I always characterize as that good strata manager, good as in experienced, professional, long-standing, gets results for their buildings. I know Rena says, I won't do less than a 2-year term because I firmly believe that it takes more than a year for us to get used to each other, to get into the flow of things, to start producing good work, and to ease out of all those administrative burdens of transferring files from a former strata manager. So 2 years could be a good place to start with a new manager. If you're not sure, or you're renewing your manager whose service has been a little bit lackluster in the last few months, you might only want to renew for 1 year. That's open to you as long as the manager agrees. So it's all about what each party is prepared to agree on. Hi, Q Poodle. Always like to see you. Interesting name, Facebook name. Q Poodle says, I've done all that, having a chat regarding service with the strata manager, also his manager, also with the licensee in charge, also with Fair Trading. Nothing came out of it. Well, let's hope that your contract term is up soon, Q Poodle, and you have some say in going with a different service provider. There are some great managers out there, okay? We've been talking a lot last 20 minutes. We've been talking a lot the last few months about poor strata management practices and poor service. There are a lot of good managers out there who we're not hearing about, we're not talking about, because they're just chugging away, doing their work for buildings to keep their show on the road. So we've got to go out and we've got to find them and be prioritizing them. Kristen's agreeing. There are great strata managers. Sean's saying, one of those times the wheel needs to be as squeaky as possible. Yep, absolutely. And demand that better level of service. Your strata manager could turn around and say, I don't do it. That's not who I am. Ain't doing it. Don't get paid enough. Don't want to do it. You're not for me and I'm not for you. Great. If you can get to that stage, then it's mission accomplished and you're able to move on. All right. Speaking of moving on, let's get into our case for today. I'm debating what part of this I'm going to show you first. Let's start here, and I'll tell you a little bit about this picture. So, not giving away any secrets here, you'll see all of this detail in the decision that we are going to share with you. This building might be familiar to those of you who know Sydney's eastern suburbs. It's been around for quite some time. It's one that I have certainly driven past, walked past many times. The Coogee View, it's on the corner of Arden Street and Carr Street, if I have that correctly. This case is about this building. In fact, it is about the yes, you can see my mouse. It is about this signage here on this building. It is a case brought by a lot owner. Yes, that lot owner was my client against another lot owner in this building. And part of the case included an allegation that the owner who installed this signage some years ago never had permission to do so. And in keeping this signage on the building, that owner was breaching the bylaws. I will get into the detail for you. It's not just about this signage, it's about a few other things as well. But my client, as an owner, an individual owner, felt that she had no choice but to bring this application because she had tried at a couple of general meetings, at a couple of strata committee meetings, to get the owners corporation to do something about this other owner's breaches, consistent and long-standing breaches of the bylaws, including this owner's very valuable right to have this signage here on the common property without approval, without paying for it. Trying to get the owners corporation and the strata committee to do something about it, and nothing would be done. So she came to me, she said, Amanda, can I, as a standalone individual owner, do anything about this? And I said, yeah, you can. It's a question that I get asked often and more these days as our buildings are labouring under big problems that cost money. Sometimes these complaints that are seen as trivial, that are seen as small compared to other things that might be going on in the building, are ignored. And owners want to know if they can take matters into their own hands. If their neighbour or somebody else in the building is breaching bylaws, causing problems, essentially treating the place as if they own it, as if they own the common property, can they do anything about it? And this is a case, a very good example of where an owner has successfully done something about it. Daryl saying this case sounds like the beginnings of the Strata Coliseum, with owners going after other owners directly by bypassing the OC. Okay, interesting take, Daryl. We have a copy of the decision for you, and I will ask Rochelle and Mina to post that one into the comments here, and I'll share my summary, as I like to do. If you haven't been through one of my case unpackings, unwrappings, unboxings, to use the influencer term, then you're in for a treat. This is how we roll. Okay. So the parties to these proceedings are three lot owners. Avago Investments were the applicant against Constantine Codis and Coogee View Proprietary Limited. So each of those parties were lot owners in the building and each respondents to these proceedings. So I start with the end first. The ultimate order that was made was that this signage that I showed you in the photo earlier was to be removed. It's signage advertising the business of AEA hotels and AEA service departments, their telephone number and their web address. It was to be removed from two places. I just showed you one place, above the car park entrance and also in the space that's located near the vent. And that's the photo that I showed you. As I understand it, as of today, the signs are gone. They are not in those locations, and the order was requiring compliance by the 22nd of May. So I think that order has been complied with. Now, what I want to focus on today is how this application was brought, what sections of the New South Wales legislation it was brought under, because that's what you guys are asking me. You're asking me that in the forum, in our Tribunal Masterclass, in our Tribunal webinar last month. You are getting really clever, and you're aware that when you fill in these applications, you have to specify the orders that you are seeking and the section of the legislation under which you're seeking those orders. And sometimes this question of one lot owner pursuing another lot owner's bylaw breach rather than the owners corporation pursuing an owner's bylaw breach, it can get a bit confusing. What section is that under? How do I do that? So the way that we did it successfully in this case was to bring the action under section 232 and section 241 of the Strata Schemes Management Act. And I'll give you a bit of a closer look at each of those. So the respondents to the application, the ones that the applicant said were breaching the bylaws, they were operating a service department business from one of the lots, which was actually a commercial lot in the Strata plan under the business name AEA Hotels. And interestingly, one of the owners, Coogee View, was also the building manager for this building. And that becomes relevant because, as you'll see here at point 8A, one of the orders that the applicant was seeking was that the respondents remove items that they had stored on the common property. The applicant said that storing items on the common property without approval is a breach of the bylaws. You don't have any approval, and therefore the items have to go. And one of the defenses that the respondent tried to run is to say, well, I'm the building manager, and under the building manager's agreement, I can put what I like on the common property. Ultimately, that particular argument wasn't accepted by the tribunal. But this is where things can get a little bit tricky, where you have lot owners who are wearing two hats. So a lot owner operating a business, a private business from the lot, and then also a lot owner who happens to be the building manager in the building. Some of our more longer standing strata buildings have these kinds of arrangements in place, and I often find that they're the arrangements that have cropped up informally, perhaps over the years, arrangements where building managers are perhaps given a little bit more latitude than they would otherwise in a more formal structure, a more formal setup. That was certainly the case in this particular building. So the applicant, in addition to seeking that those items that were on the common property be removed, the applicant was also seeking that the signage be removed and that the respondents cease exclusively using a particular area of the common property. So the tribunal has set out the orders that are being sought. Cases, in case you haven't heard me say this before, cases are a really good way, and when I say cases, I mean these decisions are a really good way to understand how to set out your own submissions. So in our tribunal masterclass for our members last week, I was asking, I'm a bit confused about submissions. What should they look like? How should they be set out? A judgment or a decision is often a really good template for your submissions. And as a lawyer, when I'm writing submissions, I'm kind of thinking to myself, I actually want to write the judgment. I want to write these submissions in such a way that the judge or the tribunal member can take them and say, yep, I agree with all of that. I'll take your submissions and I'll turn them into a decision. So you're looking at you're writing out what are the orders that I'm seeking? What is the relevant law? What are the facts? What is the evidence that proves those facts? And how do we bring all of that together? So this is a nice, neat one to have a look at if you're writing submissions, and you can use this one as a little bit of a template. Because the tribunal goes on then to look at the relevant legislation, and the tribunal starts from a place, okay, is this applicant an interested person? Do they have standing to bring this application? Especially bearing in mind that they are a lot owner suing another lot owner. So the section to have a look at, section 226 in our New South Wales legislation, an interested person can make an application to the tribunal, and an interested person includes an owner of a lot in the scheme. Interestingly, interested persons also include occupiers. So tenants can make applications. They have standing before our New South Wales tribunal. An owner of a lot is an interested person, as is an occupier under section 226, and the tribunal was satisfied of that. The tribunal then goes and has a look at section 232. I've told you that we've made this application. One of the section we made the application under is 232. Tribunal has a look at that and says, what does that say? 232 says that the tribunal can make an order to settle a complaint or dispute about any number of things, the specific subsection we relied on in bringing this application was this is a dispute about an exercise of or a failure to exercise a function conferred or imposed under the Act or the bylaws of the strata scheme. And we had gone on to say that one of the functions or duties, and you'll see in the definitions in the Act, a function includes a duty. One of the duties of a lot owner is to comply with the bylaws. And that's why we said in failing to comply with the bylaws, this lot owner was failing to exercise a function that was imposed under the Act and indeed under the bylaws separately. And we asked the tribunal in that circumstance to make an order to resolve that dispute about a lot owner's failure to comply with the bylaws. I can just see a note there from Jenny saying send the link. So Jenny, the link is here on Facebook. If you just want to scroll up, there's a lot of comments there, but if you just want to scroll up, you'll find that link. Rochelle and Mina might pop it back in there for you as well. So it's an application for an order under section 232 for those reasons, and we're able to narrow it down to subsection E. And then section 241. You don't see this one too often. And having said that, I think it was raised here on live, probably by our friend Bill and Ben recently, to say something similar. We don't see section 241 relied on too much, but it's kind of handy. I like it, and I particularly like it in this situation where a lot owner is requiring another lot owner to comply with the bylaw. Section 241 says that the tribunal may prohibit or direct the taking of specific actions. The tribunal may order any person, the subject of an application, to do or refrain from doing a specified act in relation to a strata scheme. So the tribunal can order someone to comply with the bylaws. The tribunal can order someone to stop doing something that they shouldn't be doing on the common property. And the relevant section that gives the tribunal the power to do that is section 241. Tribunal liked all that. They said applicant is an interested person. They have standing. Tribunal has power to make orders under these sections. The tribunal is satisfied that it has jurisdiction to hear and determine the application. Tribunal goes on to look at the evidence. There were affidavits filed by a representative of the applicant, affidavits filed by the other side. And as I've said, in short, the applicant was saying that the respondent had failed to comply with the bylaws by using common property storerooms without the permission of the owners corporation, installing signage on the common property, and obstructing the use of the common property. So each of those events had to be linked to a bylaw or indeed a section of the Act that the respondent was breaching. So bylaw number 3 says that an owner or occupier cannot obstruct the lawful use of the common property. Bylaw number 9 says that an owner or occupier cannot deposit any material on the common property without the written approval of the owners corporation. That's one that we relied on to say that the respondent was breaching the bylaws by storing things in the common property storerooms. Now, I've told you that the respondent was operating a service department's business and was also the building manager. And the things that were stored in the storerooms was actually bedding and linen and cleaning products associated with the service department's business. Now, the tribunal was satisfied. It says here in paragraph 24 that the respondent was using the storerooms for its own associated purposes. The respondent had said, I'm using them for my building management purposes. The tribunal did not agree with that. And the respondent was unable to produce any written specific approval for it to use the storerooms. And the building management agreement, it was found, did not provide consent to use those storerooms. Now, this is where the tribunal did not agree with us, the applicants. The tribunal has said, I don't think this is a breach of bylaw 3 because bylaw 3 is about depositing rubbish and other material on the common property. And ultimately, the tribunal didn't think that storing bedding and linen and cleaning products fell within the bounds of this bylaw. It wasn't rubbish. It wasn't waste. This tribunal member thought that bylaw 3 specifically went to waste and rubbish and things that should otherwise go in the bin. They shouldn't be on the common property. Another tribunal member might have taken a different view of bylaw 3, but in finding that it was bedding and linen and material relevant to the respondent's operation of their business being stored in the storeroom, tribunal said, I don't think that this is a breach of bylaw 3. The tribunal does go on to say that the owner's corporation can enforce rights to prevent the respondent from using the common property. Where there's no breach of the bylaws, the tribunal cannot make the orders sought by the applicant regarding the storerooms. And there's another case there, an appeal panel case, that you might want to go and have a look at and have a read of, that I'm not aware of exactly the facts in that case, but it looks like it was two lot owners having a dispute about compliance with the bylaws. So another good one to have a look at there. So while the tribunal did not order that there was a breach of bylaw 3 and get the items out of the storeroom, I am told that those items are no longer in the storeroom as of today, which sounds like a good result to me. Issue number 2, signage on the common property. The applicant says the signs have been installed without the consent of the owner's corporation, and the applicant has been unable to ascertain that the signs have approval. We connected the signage to bylaw number 5. The signage is causing damage to common property. That's a breach of bylaw 5, and also section 111 in the Act that says you can't carry out work on the common property without the consent of the owner's corporation. Respondent said it wasn't me who put the signs up. Signs were always there. Developer put the signs up. The tribunal didn't accept that evidence and found that by installing the signs, the respondents had attached them to common property without being able to satisfy the tribunal that they had the consent of the owner's corporation. In doing so, they failed to comply with bylaw 5. They've damaged the common property without any approval, and they're in breach of section 111 of the Strata Schemes Management Act. So the tribunal has ordered that the signage in 2 places be removed. And as I said earlier, that signage, I'm told, is now gone. So a very valuable right in the hands of that business owner now being returned to the owner's corporation for the owner's corporation to decide what it wants to do with its common property and whether it might want to offer that owner the opportunity to advertise its business in return for a fee, or offer that to somebody else, or indeed auction off the opportunity to use the common property in that way. The final issue was about an area of the common property that the applicant said the respondents were using exclusively for themselves. And the point that I'm trying to make here is that with each of these allegations, it's been incredibly important to link the behavior or the use of the common property or the thing that's going wrong, link it to a bylaw. That is how one lot owner sues another lot owner. You need to be able to say they are in breach of the bylaws. If you can't do that, then you're going to have trouble establishing that the tribunal has jurisdiction to deal with your complaint. So in using this area of the common property, the applicant said that there was a breach of bylaw 3, there is an obstruction of the common property, and ultimately it turned out that the tribunal did not agree with that. The tribunal said that the only way to access this property is through this lot, so we can't really say that there is an obstruction of the common property being caused here. This is just the way that this particular building has been constructed and the way that the strata plan has been drawn. So the ultimate order was that the signage be removed by a certain date. There was no order about the exclusive use of the common property without approval, and there was no order about the storerooms. The signage is now gone, and interestingly, as I understand it, the storerooms are now empty. So happy applicant in that case. No costs order made in that case. Ultimately, an order that each party pay their own costs. And you can see from these directions that the tribunal gave the parties the opportunity to seek a different order and to ask for a cost order in their favour if they wanted to make that application and make those submissions. Neither party decided to seek a cost order in that case. Just seeing a comment there from Mark saying, who paid the costs to remove the signage and return it to its original state? Yeah, so the respondent did that. That was their responsibility under those orders. Joseph is saying, if no bylaws, don't model bylaws become the bylaws that can be breached? Yeah, absolutely. So model bylaws are bylaws. And Josephine, I have a vague feeling that you might be in Victoria. So yes, your rules, as you call them in Victoria, you have model rules, I think, as well. They are your bylaws, and they have exactly the same status as any other bylaws that may otherwise be made after the registration of the strata plan. Just scrolling back up to see if we've got some questions and some comments on this one. Kiri saying, why was this action not taken against the Strata committee and who should be following the bylaws? It was the applicant's decision that it did not want to bring proceedings against their owners corporation. Certainly there was no cause of action against individual Strata committee members. There could possibly have been an action against the owners corporation, but this applicant decided that they didn't want to drag their fellow lot owners through proceedings unnecessarily when they were seeking to correct the behavior of one lot owner in particular. So that was the decision that was made in that situation. Shana saying, yay, you recommended section 241 in my member call, number 100. Yes. So if that's got a number on it, Shana, we must have published that member call already. I think it was a few weeks ago. So yes, we were talking about section 241. That's a good one for any of our members to go and have a listen to and to hear more about how you might frame an application around that section. Jenny saying, sorry, started late. Would this enable an owner to require a lot owner to only use the lot for its approved use, DA consent? For example, hotel lot not to be leased for more than 6 months. Is the lot owner breaching a bylaw? That's my starting point. As I said, Jenny, and I might have said this after you posted that, if a lot owner is going to sue another lot owner, I'm encouraging you to be thinking about what bylaw is my neighbour or fellow owner breaching, because that is how you establish the jurisdiction of the tribunal here. There may be a bylaw about use, and maybe that bylaw is being breached. Sean saying, whenever preparing a complaint about anything, I always list all the possible breaches I can think of in descending seriousness. Don't ever think minor breaches aren't worth raising. They may be the ones that get through, but always make sure they're supportable. Yeah, I really like that thinking, Sean. And you're looking over my shoulder when I'm preparing these kinds of applications. That's the same thing that I do. And you don't always know what's going to get up before the tribunal, right? So in some situations, it's a good strategy to make, I used this word the other day with a client, to make a bit of an ambit claim. You want to be careful about that because you don't want to put forward frivolous or vexatious applications or proceedings. You want to make sure that you can back up each of your claims. But sometimes the tribunal will accept some things and not others. And that's definitely the situation, the case with this situation here, with this case that I've just shared, that some things were successful and other things weren't. But as it turned out, the right result, we ended up with the right result at the end of the day. So especially with the tribunal, you kind of don't really know how things are going to turn out. We thought we might have been more successful on another point in that application. Turned out to be one that we weren't necessarily expecting. All's well that ends well at the end of the day. Deborah saying, what if there is an obstruction to an electrical meter and safety switch in an exclusive use area? Can you breach, or does the exclusive use stop it? Yeah, great question, Deborah. And it's funny when you, I don't know if it's in the decision, but when you read this, there was a similar situation here about electricity supply. Have a look. If there is a bylaw for exclusive use, you want to go and have a look at the terms of that bylaw and just see whether the terms of the bylaw require the owner who has the exclusive use to permit access for certain reasons, or access to certain items. And if the bylaw doesn't deal with that, and that's a safety issue, then that might be one of the reasons why the bylaw could be challenged, or the bylaw needs to be amended, or otherwise dealt with to make sure that that can all happen, so that there is access available for the owners corporation. Okay, that case available for you. There is a link here in our Facebook comments. We'll get that over to YouTube as well. If you're ever on LinkedIn and you're tuning in, we tend not to fill up our LinkedIn comments with too many of these resources, but please, if you're hearing me mention a resource and you'd really like it, just post into the comments on LinkedIn under my talking head there that you would like this resource, and we'll make sure that we get it to you. Now, we are soon going to wrap up, but community service announcement to make first of all. If you are not already a paying member inside our online membership community, I encourage you to listen up. On the 1st of July, the price of new memberships is going to increase. Some of you will have heard me say this on the podcast this week. Those of you who are current members will have received a couple of messages from me about this. Our price for new memberships is increasing by at least 18% from the 1st of July. Now, this does not affect our current members. I want to be super, super clear about this. My promise to you, as it always has been since 2016, since we first kicked off this membership, is that your membership will always remain the price that you paid when you came in. It will not increase, even though the value of what is inside our membership platform is increasing every month, and the price for our new memberships certainly goes up. The current price for a monthly owner membership is $67 a month. Yes, some of you are paying you less than that because you've been with us for 7 years or 6 years or 5 years. The current price is $67 a month. On the 1st of July, that price is increasing to $79 a month. Super clear, this does not affect our current members. This is not Netflix, right? Even though I'm adding more resources, there's more answers there in our forum, there's more helpful content, I do not charge my current members more than the price that they came in on. But if you are not yet a member, it's important that I make it really clear that membership will never be as cheap as it is today. So if you've been thinking about joining us on the inside, now's the time to come on in. And I know that some of you heard this message already on the podcast because I've seen your memberships come on in. For the life of your membership, you will secure that $67 a month pricing. You'll actually pay less than that if you choose to pay annually. So the place to go if you want to find out what this membership is all about that I'm talking about and make sure that you can secure that low pricing is stratamembership.com. And if you are a member, as I know from these names here that many of you are, if you have a friend, if you have a neighbor, a colleague, a family member who you know will love our membership community, will benefit from all that we share, do encourage them to join before the 1st of July so that they can get this current pricing before it goes up. And I know some of you have already been doing that because we've had a few people join this week who tell me that they were referred by their friends. So that's really cool to hear that you're supporting each other. With our pricing increasing to $79 a month, there is $144 saving to be had now. So the place to go to secure that saving now and for each year of your membership is stratamembership.com. And a quick word about our pro memberships. Our pro membership pricing is increasing as well. That's for our Strata managers and for our Strata committees where you have a group membership, not for our current members, only for new members. That pricing is going up by 20%. So if you've been wanting to get your committee inside the membership or your Strata manager or your Strata manager friends, reach out to me now and we'll talk about your options for pro membership. Just do that before the 1st of July so you can get the best price. All right. Thank you for all the thank yous. I don't know, was I going to slip up and say the dirty word? Was it Sean? Yvette is saying that she's on LinkedIn or needs LinkedIn. Enjoy the weekend. You too, Petra. My pleasure, Wendy. Thank you, everybody. I'll skip back over to those comments and make sure that I have acknowledged everyone. Have a fantastic weekend in Strata. We have soon to be new fish in the house, not for Friday night takeaway. Fish, there's a fish tank that's being set up in this room that's next to me here. So I think that's what we're going to be working on this weekend. And any of you who have had fish before and they have survived, you know the effort that goes into ensuring that that's the case. So hence it is quite a process. That's what I'm doing. Hope you're doing something fun. And I'll definitely be here this time next week to catch up with you all. Bye for now.